The Kenya National Commission on Human Rights has called you here today to share with Kenyans our progress report on our investigations into human rights abuses in the ongoing crackdown against terrorism. As you all know, the Commission is a national human rights institution established under Article 59 and Chapter 15 of the Constitution of Kenya and subsequently operationalized through the Kenya National Commission on Human Rights Act 2011. Specifically, we are mandated as a commission by Article 59, 1, D and E of the Kenyan Constitution to, under Part D, monitor, investigate, and report on the observance of human rights in all spheres of life in the Republic, including observance by the national security organs, which is the subject of this report. Number 2, to receive and investigate complaints about alleged abuses of human rights and take steps to secure appropriate redress where human rights have been violated. And as my colleague said, we received a lot of complaints, and this is part of our efforts to seek redress for those who have suffered acts of human rights violations. Further, Section 8E of the Kenya National Commission on Human Rights Act 2011 mandates the Commission to, on its own initiative, or on the basis of complaints, investigate or research matters in respect to human rights and make recommendations to improve the functioning of state organs. So we hope today's recommendations will be taken seriously by the relevant agencies so that we have a state that truly respects human rights. The Commission, as has been said, as you've heard in the brief, is currently investigating allegations of human rights violations by security agencies in the ongoing crackdown on terrorism and general insecurity in the country. In conducting this exercise, we are guided by Article 238(2)(b) of the Constitution, which provides, and I quote, that national security shall be pursued in compliance with the law and with utmost respect for the rule of law, democracy, human rights, and fundamental freedoms. The key object of the exercise was to ensure that all efforts by government to contain terrorism as a threat to national security are conducted in accordance with the rule of law and in compliance with human rights standards and principles. Preliminary evidence gathered by the Commission establishes a pattern of conduct by the Kenyan security agencies amounting to grave violations of the law and human rights against individuals and groups suspected to be associated with terror attacks in various parts of the country. And as was reported earlier, mainly in Nairobi, Wajir, Mandera, Garissa, Lamu, Tana River, Kwale, Kilifi, and Mombasa counties. The Commission has established that several people have disappeared, several killed, and scores of others tortured in the ongoing operation. The counter-terrorism operations are being conducted by a combined contingent of Kenya Defense Forces, the National Intelligence Service, NIS, the Kenya Wildlife Services, county commissioners, deputy county commissioners, chiefs, and various units of the National Police Service, including the Anti-Terrorism Police Unit, the Kenya Police Reservists, Rapid Deployment Unit of the Administration Police, the Border Patrol Unit, and the General Service Unit. This report documents over 120 cases of egregious human rights violations that include 25 cases of extrajudicial killings and 81 cases of enforced disappearances. As detailed in the report, these violations are widespread, systematic, and well coordinated, and include but are not limited to arbitrary arrests, extortion, illegal detention, torture, killings, and disappearances. The Kenya National Commission on Human Rights has had multiple narratives of suspects being rounded up and detained for periods ranging from a few hours to many days in extremely crowded and under inhumane and degrading conditions. Many have been tortured while in detention, sustaining serious physical injuries and psychological harm as a result. The torture methods include beatings, waterboarding, electric shocks, genital mutilation, exposure to extreme cold or heat, hanging on trees, mock executions, and exposure to stinging by ants in the wild, as well as denial of sleep and food. The families of the disappeared have complained that they have received no assistance from the government and continue agonizing as they desperately search for their kin. Kenya National Commission on Human Rights has further confirmed the existence of suspicious graves in Wajir County at a place called Landville, which contained remains of dead persons whose circumstances of death remained unexplained, further raising concerns of possible human rights violations. The Commission is concerned that the ongoing crackdown affects or is targeting members of the Somali ethnic community and those of the Muslim faith. This profiling of people along ethnic or religious lines is discriminatory and is therefore unconstitutional and against both national, regional, and international human rights norms and standards. The Commission is alive to the immense challenges that the government faces in combating terrorism and insecurity. While supporting ongoing efforts by the state to combat terrorism, the Commission maintains and insists that security policies and practices must be legal and consistent with human rights standards and principles. Combating terrorism through official terror is counterproductive and only serves to foment further resentment, increases radicalization, and fertilizes the breeding grounds of future terrorists. The Commission seeks a guarantee from the government in respect of the security of the witnesses, victims, and family members who are willing to give information on the violations but are afraid to do so for fear of reprisals. The Commission calls for unconditional and unfettered access to information that is crucial for it to conclude its investigations and to have access to all places where the detainees are being held to enable us to fulfill our constitutional and statutory mandate. Ladies and gentlemen, we have a few recommendations that we want to make arising out of the report. The first recommendation is that we are calling upon the President to acknowledge and condemn the abuses by security agencies and ask them to ensure respect for the rule of law and human rights in the fight against terror. He should issue an official apology to the survivors and families of the victims of these abuses, which we have properly documented in the report that you've seen. We're also calling upon the Independent Policing Oversight Authority, IPOA, to investigate the abuses that have been highlighted, that touch on their mandate, and take action against the police officers found to be responsible or culpable. We are calling upon the Director of Public Prosecutions to direct the Inspector General of Police to ensure prompt and comprehensive investigations are conducted into the ongoing abuses by security agencies and to ensure that those responsible are prosecuted. We are further calling on the Inspector General of Police to immediately instruct, through an official circular, all police stations to accord our Commission the requisite assistance to enable us execute our constitutional mandate, especially in terms of access. Because as it was said earlier, we've had a lot of stonewalling and some of the information that we're seeking we can't get to because the police are not fully cooperating with us. We are calling upon the National Police Service Commission and the Office of the Inspector General, as well as the Ministry of the Interior and Coordination of National Government, to prioritize resourcing and tooling of security officers to ensure effectiveness and efficiency in addressing terrorism and other forms of insecurity. To the Chief of the Kenya Defense Forces, we want him to issue clear instructions to all military personnel that abuse of civilians or suspects, including torture, extrajudicial killings, and arbitrary arrests, are illegal and will not be tolerated. We want the Chief of the Kenya Defense Forces to also direct the military police to conduct investigations of crimes and other human rights violations committed by the military personnel and to hold those responsible to account. Further, we are calling upon the Chief of the KDF to issue clear instructions to all military personnel that the detention of civilians in military custody is illegal and will not be tolerated, and to display an order to this effect publicly in all military camps. The Chief of the Defense Forces should instruct his commanders to grant Kenya National Commission on Human Rights unfettered access to information and facilities crucial to its investigations in line with Article 59 2D of the Constitution. And this is actually in line with what we said earlier, because we have information that some of the military bases could be operating as torture chambers, and we have to get to the bottom of those allegations. We are calling on the Parliamentary Committee on Defense and National Security to conduct an independent probe on the abuses committed by the KDF, particularly in relation to the issue of the torture chambers in the military bases in Wajir, Mandera, and elsewhere. We are also asking Parliament to restrict the involvement of the military in internal security affairs, given the refusal by KDF to be held accountable for their actions. And we are extremely worried about the suggested proposals in the Kenya Defense Amendment Bill, which seek to host the parliamentary oversight role, and we are actually taking this early opportunity to say that we'll challenge those proposals vigorously. We are also asking partner governments and donor agencies who are supporting the Kenya security apparatus to insist, as a condition of their assistance, on compliance with the rule of law, respect for human rights, and accountability for abuses during operations by the security forces, so that the Kenya security forces do not have a carte blanche. Those ones who are found to be violating human rights and who are also beneficiaries of donor funds, who are beneficiaries of external assistance, that assistance should be pegged on the ability of the security forces to be in the forefront of upholding the rule of law and respect for human rights. Finally, ladies and gentlemen, we are, as my colleague said, also extremely worried about what the government is planning to do in the ongoing operations in the Boni Forest. And we are saying this because as a commission we have a history. We know what the military did when they went to Sabaut to quell the so-called the Sabaut Land Defense Forces. They adopted a scout-up policy, and in Boni Forest, our biggest concern is that there are families there, especially the forest-dwelling families. We have information about 400 or so families who have been told to evacuate and leave that place without the requisite arrangements being put in place to ensure that their livelihoods, especially because they depend on that forest, is secured. But more importantly, that this operation will not be carried on the same parameters as previous operations, whereby instead of helping to keep this country safe and secure, we end up using extra legal measures that only swell the ranks of those ones we are trying to fight and defeat. Therefore, we end by saying it's indeed erroneous for the government to think that they can fight and defeat terror by using terrorist methods. Thank you.